a statute that's been in place for a long time. It's section 110.1. You can look it up on OSCN. Originally, the law says it is the policy of this state to assure that minor children have frequent and continuing contact with parents who have shown the ability to act in the best interest of their children, and to encourage parents to share in the rights and responsibilities of rearing their children after the parents have separated or dissolved their marriage. It's interesting, we'll start there, because after the parents have separated or dissolved their marriage, completely does over the paternity actions, whereby you have no rights until you establish them. And so the fact that you are separating is now a basis for you to have responsibility and ability, frankly, to rear your children. So that aside, it continues, provided that the parents agree to cooperate and that domestic violence, stalking, or harassing behaviors, as defined in Section 109 of this title, are not present in the parental relationship. In other words, it used to say that if you don't agree to cooperate, that domestic violence, stalking, or harassing behaviors are evident, then you can't get joint custody. And then it continues, to effectuate this policy, if requested by a parent, court may provide substantially equal access to the minor children to both parents at a temporary order hearing, unless the court finds that shared parenting would be detrimental to the child. The new statute goes beyond just this temporary hearing, includes language regarding a final hearing, meaning your paternity case or your divorce, not just that temporary order. And Brian will break down the difference between the final and the temporary here in a minute. But some significant changes that occurred in this. One, basically saying that the court may consider evidence of the ability of the parents to cooperate, which changes from have shown the ability, have provided that the parents agree to cooperate and that domestic violence, stalking, or harassing behaviors as defined, blah, 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 are not present. So now we're saying basically the court can consider the ability of the parents to agree rather than, well, if they can't agree, or this domestic violence, stalking, or harassing behaviors. Now, court can consider this ability to cooperate. Court can consider evidence of domestic violence. Court can consider stalking and specifically harassment rather than, quote, harassing behaviors. Prior to the change, this specific language "are not present in the parental relationship" was a basis for them not to order joint custody. Now, this is something that can be considered in the totality of circumstances, whether or not it exists or not, has an effect on a joint custody determination, but is not dispositive thereof. You want to break down how evidence of domestic violence, stalking, or harassment, while still persuasive, is no longer presumptive, makes a big difference in custody.